At the present time, new material related to the conviction of Lucy Letby is being reviewed by the Criminal Cases Review Commission, often shortened to the acronym CCRC. The Commission will decide whether the conviction of the neonatal nurse is safe or could possibly be undermined by this new information. In this video, we will assess the likelihood of the CCRC referring the case to the Court of Appeal. Part 1. What is the CCRC and Court of Appeal? The Criminal Cases Review Commission is the independent statutory body that investigates possible miscarriages of justice in England, Wales and Northern Ireland after the ordinary appeal process has been exhausted. It does not itself overturn convictions. Its key power is to refer a conviction or sentence back to the appropriate appeal court if it considers there is a real possibility that the conviction will be quashed or the sentence altered. The CCRC was created by the Criminal Appeal Act 1995 and began work on the 31st of March 1997. Its creation followed a series of notorious miscarriages of justice, including the Guildford 4, Birmingham 6, Maguire 7 and Judith Ward cases. Those cases exposed problems involving false confessions, police misconduct, non-disclosure and unreliable forensic evidence. A Royal Commission on Criminal Justice was established in 1991 and recommended removing the power to refer suspected miscarriages of justice from government ministers and placing it in an independent body. I must say as well, it's extremely likely that the government decided that we don't want to be dealing with this anymore, let's create a body and then we can just say we're not involved in this in any way, although that is not the official reason that the Criminal Cases Review Commission was created. Before the CCRC existed, cases that had already been through the appeal system could, in some circumstances, be referred back by the Home Secretary. The CCRC was intended to create a more independent and investigative system, separate from both government and the courts. Indeed, the Home Secretary had been directly involved in the infamous case of the Birmingham 6. The practical role of the CCRC includes obtaining police, prosecution and court material, examining undisclosed records, commissioning scientific or medical experts, considering changes in the law, and tracing or interviewing witnesses. It can investigate material that was never available to the original jury. The important distinction is that the CCRC asks whether there is a real possibility that an appeal court would overturn the conviction. It does not decide whether the applicant is guilty or not guilty. The Court of Appeal, as the name would suggest, is a court, whereas the CCRC is an investigative and referral body. For Lucy Letby, the relevant part is the Court of Appeal Criminal Division, which is the second highest criminal court in England and Wales, behind the Supreme Court. The Supreme Court probably won't become relevant in the Lucy Letby case, as it only deals with procedural issues. The principal criminal role of the Court of Appeal is to hear appeals from the Crown Court, including appeals against conviction and sentence. When considering an appeal against conviction, its central question is whether the conviction is unsafe. It does not normally conduct an entirely new trial, instead it examines the original proceedings and any admissible fresh evidence or argument and decide whether the conviction can safely stand. It should be stated as well that the Court of Appeal does have the power to order a retrial and has used this power recently in a high-profile case. The modern Court of Appeal dates from the Court of Appeal created in 1875, although criminal appeals were historically dealt with separately by the Court of Criminal Appeals from 1907. The present criminal division of the Court of Appeal emerged when the Court of Criminal Appeal was absorbed into the Court of Appeal under reforms in the 1960s. The Court of Appeal can dismiss an appeal and uphold the conviction, quash the conviction, substitute another appropriate conviction in certain circumstances, order a retrial, or alter a sentence. In exceptional cases involving a point of law of general public importance, a further appeal may ultimately reach the UK Supreme Court, but for most challenges concerning factual safety or new evidence, the Court of Appeal Criminal Division is effectively the decisive appellate court. The CCRC effectively acts as a post-appeal safety net. If somebody has already unsuccessfully appealed but later discovers significant new evidence, for example, new medical science, an undisclosed police document, a new witness, unreliable expert evidence, or some other potentially important development, they can ask the CCRC to investigate. The CCRC then asks, is there a real possibility that the Court of Appeal would not uphold this conviction? If the answer is yes, it can refer the case. The Court of Appeal then asks the separate and ultimately more important question, is the conviction unsafe? Lucy Letby has already been through the ordinary Court of Appeal process in relation to her original convictions, indeed on 2 occasions. Her current application, therefore, asks the CCRC to assess new evidence and arguments that were not considered in that earlier appeal. If the CCRC concludes that the new medical, scientific, statistical and other evidence creates a real possibility that the Court of Appeal would find the convictions unsafe, it can refer them back. The Court of Appeal would then decide whether the conviction should remain in force, be quashed, or potentially be followed by retrials. Part 2. CCRC stats on referring cases. The latest official CCRC figures give a useful sense of how unusual referral is. From April 1997 to the end of May 2026, the CCRC received 35,331 applications and referred 921 cases to an appeal court. That is a crude overall referral rate of about 2.6% of applications received. Of the 878 referred appeals that had actually been heard, 618 succeeded, 242 were upheld, and 18 were abandoned. So among referrals that reached a judicial decision, roughly 72% were successful. So essentially what you can derive from that is that a very small number of cases are referred to the Court of Appeal, and then most of those cases are effectively overturned. What I should also say is that although that's a very small number of cases that were referred, and certainly I believe that number should be bigger, it's possible that as there are 35,000 applications, that some of those people are actually guilty. We cannot assume that all 35,331 applications, obviously these are not all separate people, some of them will be duplicate, but it's going to be tens of thousands of people. We can't assume that they're all necessarily innocent. The more recent annual figures are particularly interesting. In 2024 to 2025, the CCRC referred 31 cases. During that year, 27 previously referred appeals were heard, 18 were allowed, and 9 dismissed, meaning 2/3 succeeded. In 2024 to 2026, referrals rose sharply to 45 cases, up 45% on the previous year and 80% compared with 2 years earlier. The CCRC received a record 1,841 applications during 2025 to 2026. Historically, the CCRC itself has described its referral rate as being around 2% of applications, so the overwhelming majority of applications are not sent back to court. One important qualification is that cases referred includes both convictions and sentences, and recent figures have indicated a substantial number of what are referred to as IPP/DPP sentence referrals. This means imprisonment for public protection and detention for public protection. So the overall 2 to 3% figure should not be treated as the exact probability of a murder conviction being referred. That could in fact be somewhat higher, or certainly slightly higher than this 2 to 3% figure. In the case of Lucy Letby, the most useful statistical point is this. The CCRC is highly selective at the referral stage, but once it does refer a case, the appeal succeeds considerably more often than it fails. Historically, nearly 3/4 of referred cases have ultimately succeeded in the appeal courts. On the downside, fellow nurse Colin Campbell was fairly recently unsuccessful in overturning his conviction, although I must say that in my view he received an extremely poor defence at the Court of Appeal. Referral does not mean acquittal, but referrals often succeed. An interesting statistic is that since 1997, according to the CCRC, 921 cases have been referred, 878 referred appeals have been heard, 618 have been successful. If you exclude abandoned cases, that means approximately 71.9% of decided appeals following a CCRC referral have succeeded. So over 7 out of 10 CCRC referrals ultimately result in the conviction being quashed or the sentence being successfully challenged. That tells us something important about the threshold. The CCRC does not refer cases casually. Once it has concluded that the statutory real possibility test is satisfied, the appeal courts subsequently agree in a substantial majority of cases. I wanted to look as well at some striking individual years because the variation is interesting. There's certainly an upward trend, broadly speaking, the number of referrals. Back in 2016 to 2017, there were only 12 referrals, and the CCRC itself acknowledges that this is well below its historical average. In 2018 to 2019, there were just 13 referrals. Conversely, in 2020 to 2021, there were 70 referrals, though this was overwhelmingly influenced by the Horizon IT scandal. And 88% of referrals, again probably influenced by the Post Office issue, succeeded in that year. Again, there were 63 the year later, again influenced by Horizon, and then it had fallen to 27 by 2024-25. As you've just heard, it has since risen again, and there has been something of a public effort to indicate that the CCRC is more receptive to appeals and to sending appeals to the Court of Appeal than has been the case historically. Part 3. Requirements of the CCRC. Also relevant here is the statutory threshold for referral. That is not that the CCRC believes the applicant is innocent. The CCRC refers where it considers there is a real possibility that the conviction or sentence would not be upheld. A recent example involved a case in which the Commission initially provisionally decided not to refer, received further submissions, reconsidered them, and then referred because it concluded there was a real possibility the Court of Appeal would quash the convictions. The CCRC's referral test is quite specific. It does not have to decide that someone is innocent, and it does not have to conclude that a conviction is definitely unsafe. Its statutory question is whether there is a real possibility that the appeal court would not uphold the conviction if the case were referred. That test comes from Section 13 of the Criminal Appeal Act 1995. For a conviction, 3 things normally have to be present. A real possibility the conviction would not be upheld. This is deliberately lower than saying the CCRC itself thinks the conviction should be quashed. The CCRC is effectively predicting what the Court of Appeal might realistically do, not substituting itself for the court. The real possibility must normally arise from new evidence or new argument. In statutory language, it should be evidence or argument that was not raised at trial, on appeal, or in an application for leave to appeal. The normal appeal process should already have been exhausted. Usually an appeal must already have been determined or leave to appeal refused. The CCRC is designed as a post-appeal safety mechanism rather than an alternative to appeal. There is an important escape clause which is exceptional circumstances. Section 13(2) allows the CCRC to refer even where the evidence is not technically new or where the applicant has not previously appealed if exceptional circumstances justify doing so. The CCRC says such circumstances are rare and assessed on a case-by-case basis. However, here is the Section 13 clause. Nothing in subsection 1, B, I or C shall prevent the making of a reference if it appears to the Commission that there are exceptional circumstances which justify making it. So I'm not sure if this would apply in the case of Lucy Letby. I know that this is an argument that will be made, but whether they would agree that there were truly exceptional circumstances or not, I'm not sure. Unfortunately, the fact that it's an unsafe conviction and a wrongful conviction that Lucy Letby is innocent may not be considered exceptional circumstances. It's hard to know what the court would define as exceptional circumstances, but this may not be allowed. However, we're going to discuss fresh evidence later in this video. The phrase real possibility is especially important. This is not the same as more likely than not. The CCRC does not need to conclude there is a 51% plus probability that the Court of Appeal would quash the conviction, nor is it enough that an argument is merely conceivable or fanciful. In practical terms, the new material has to be sufficiently credible and significant that there is a realistic prospect of the court concluding that the conviction is unsafe. The CCRC itself describes the requirement as new information convincing enough to raise a real possibility of the appeal court overturning the conviction. Another point that is sometimes misunderstood is that new evidence does not necessarily mean newly discovered facts in the everyday sense. It can include a new expert opinion, new scientific research, newly obtained documents, new witness evidence, or new legal argument, provided it was not previously raised in the relevant proceedings. The Commission has investigatory powers under Section 17 and 18A to obtain material from public bodies and, with a Crown Court order, from private persons or organisations. It can also commission new expert evidence and re-interview witnesses. The CCRC is therefore not restricted to asking, has someone found a document nobody knew existed? It can ask whether new analysis of existing material fundamentally changes its significance. That distinction could be particularly important in a medically complex case. As an example, let's say a jury saw a laboratory result and heard one interpretation of it. Years later, new peer-reviewed neonatal research demonstrates that the biological assumption underpinning that interpretation may not apply to neonates. Of course, we know there's evidence out there in this very case. Even though the original blood result itself is old, the scientific argument about what that result means can potentially constitute new evidence or argument for CCRC purposes. Similarly, if new specialists review the same contemporaneous medical records and identify previously unpresented diagnoses or treatment-related explanations, the CCRC has to consider whether those opinions are genuinely new and sufficiently persuasive to create a real possibility of a successful appeal. It cannot simply say the jury already saw the medical notes if the materially different expert interpretation was never presented to the jury or the Court of Appeal. The statutory focus is on whether the evidence or argument was previously raised. There is also an important distinction between the CCRC's test and the Court of Appeal's eventual test. The CCRC will ask, is there a real possibility the conviction would not be upheld? The Court of Appeal will ask, is the conviction unsafe? If the CCRC refers a case, it has not declared the person innocent or not guilty, and it has not itself quashed anything. The Court of Appeal then conducts the appeal and decides whether the conviction is unsafe. This explains why referrals are comparatively rare but often successful. The CCRC acts as a filter. It should refer when the new material has crossed the statutory real possibility threshold, not only when it has itself become convinced of innocence. Part 4. Current reputation of the CCRC. I think it's reasonable to say that the CCRC's current public reputation is poor, although that should be distinguished from saying that all of its casework is poor or that it is incapable of making sound referrals. What makes that assessment particularly defensible is that criticism is no longer coming only from campaigners or unsuccessful applicants. It has come from an independent KC-led review, a cross-party House of Commons Justice Committee, the Ministry of Justice, and the CCRC's own new leadership. The clearest examples are these. Andrew Malkinson. This is the most damaging case. He spent 17 years in prison for a rape he did not commit. The CCRC rejected earlier applications and failed to pursue material that could have led to his exoneration years sooner, many years sooner, 14 years sooner. Chris Henley Casey's independent review found a catalogue of failures and concluded that Malkinson could potentially have been cleared over a decade earlier. The CCRC subsequently accepted the recommendations and apologised, which was big of them, I'm sure you'll agree. The Justice Committee's 2025 report was exceptionally severe. The cross-party committee said the organisation required a root and branch review that its leadership had shown a remarkable inability to learn from its own mistakes, and that its handling of the Henley report amounted to a spectacular failure of leadership. It explicitly said the situation at the CCRC had deteriorated significantly. As a consequence, Helen Pitcher resigned in January 2025, previously the chair of the CCRC, after an independent panel concluded by a majority that she should no longer head up the organisation. The Lord Chancellor had been moving towards recommending her removal. The panel found that she had failed to inspire confidence following the Malkinson case. The chief executive also resigned. Karen Neller resigned in July 2025 after the Justice Committee concluded that her position was no longer tenable. When Dame Vera Baird announced the resignation, she said it explicitly that confidence in the organisation had been badly damaged and needed to be restored. There were also criticisms about institutional defensiveness. The Justice Committee thought the CCRC had been too concerned with defending its own reputation after the Malkinson miscarriage. It criticised the delay in apologising and said its public statements gave the impression that leadership was more interested in protecting the organisation than openly acknowledging how badly it had failed Malkinson. There were concerns that the Malkinson errors reflected systemic rather than isolated problems. Henley identified issues including inadequate investigation, weak oversight, and resource pressures. The Justice Committee specifically rejected attempts to treat the findings as merely one unfortunate case, saying they had significant implication for the CCRC's broader approach to casework. I should say that this kind of institutional defensiveness and intransigence is certainly not limited to the CCRC, as people following this case will be only too aware. The CCRC was also criticised over management and working practices. The Justice Committee highlighted difficulties recruiting sufficient commissioners and criticised a remote-first working model as apparently unsuited to the organisation's highly sensitive investigative work. Even after the leadership changes, concerns have continued. A July 2026 inspection said the CCRC needed urgent improvement in areas including proactive casework quality assurance, although importantly, the inspector did not conclude that the organisation was fundamentally unfit for purpose. This is a critical qualification, and it's fair to say that a statement such as the CCRC is completely discredited is not fair. It is fair to say that it has received wide-ranging and strong criticism, and that it has not responded well to previous criticism. The CCRC continues to uncover and assess miscarriages of justice. Referrals frequently succeed, and its more recent leadership appears to acknowledge that reform is necessary. Dame Vera Baird was specifically appointed with a mandate to review the organisation and rebuild public confidence, and her interim appointment has since been extended so that she can implement reforms. The CCRC enters the Letby case with its public reputation perhaps at its lowest point since the organisation was created. The Andrew Malkinson scandal led to a damning independent review, the resignation of both its chair and chief executive, and a cross-party parliamentary committee concluding that the organisation required root and branch reform. Its own new chair has acknowledged that public confidence has been badly damaged. And it should finally be noted that all of this criticism is cited and based around its failure to refer and overturn cases, often for people who later turned out to be demonstrably innocent. That is all extremely important contextually when it comes to the Lucy Letby case. Part 5. The appointment of Dame Vera Baird. Dame Vera Baird's tenure at the CCRC has been short but unusually consequential. She was brought in specifically as a reform chair, not simply as a caretaker. She took office as interim chair on the 9th of June 2025 after Helen Pitcher resigned amid the fallout from the Andrew Malkinson case and consequent severe criticism from the Justice Committee, which we've already discussed. Her original appointment was due to run until the 8th of December 2026. The Lord Chancellor explicitly tasked her with carrying out a thorough review of how the CCRC operates, strengthening governance and rebuilding public confidence. Her starting point was therefore unusually difficult. Just weeks before she arrived, the Justice Committee had said the previous leadership showed a remarkable instability to learn from its own mistakes and called for root and branch reform. One of Baird's first public positions was quite stark. When long-serving Chief Executive Karen Neller resigned in July 2025, Baird said that confidence in the CCRC had been badly damaged and had to be restored. Indeed, I just read her quotation in the previous section. That was significant because the new chair was openly acknowledging institutional failure rather than defending the existing regime. Baird will of course be aware that this has been a failing of the CCRC previously. She then initiated a substantial external examination of casework. In September 2025, she commissioned His Majesty's Crown Prosecution Service Inspectorate to inspect the CCRC's casework as the central part of her wider review. That inspection reported in July 2026. Interestingly, although it identified areas requiring improvement, it examined 60 sampled cases and found that the casework teams had reached sound and correct conclusions in all 60. It also praised staff commitment. That gives Baird's tenure an important nuance. She inherited an organisation whose leadership and governance reputation was extremely poor. Baird has also overseen considerable personnel change. 6 additional commissioners were appointed in May 2026, taking the number to 16 commissioners in total. Since commissioners, not the chair personally, make the statutory decisions on referrals, expanding that decision-making capacity is significant. The executive leadership has also been restructured. After the departure of Neller, Amanda Pierce became interim chief executive, and Tracy Kalea was appointed as the next interim CEO, joining in March 2026. Baird specifically welcomed Kalea's lengthy justice system experience, and apologies to Tracy if I haven't pronounced her name correctly, it's quite unusual. There has also been a visible increase in CCRC activity during the period. In 2025 to 2026, the Commission received a record 1,841 applications and made 45 referrals, a 45% increase on the previous year and 80% above the level 2 years earlier. That cannot be entirely attributed to the appointment of Baird. She arrived partway through the reporting year and individual commissioners determine cases, but it does show that her tenure has not coincided with institutional paralysis. There have been notable successful referrals as well. In April 2026, the Court of Appeal dealt with several historic IPP and DPP sentences, including 3 that were referred by the CCRC. And in July 2026, a woman convicted as a 14-year-old while being subjected to grooming and sexual exploitation had her convictions quashed following a CCRC referral. Perhaps the clearest indication that government is satisfied with Baird's reform work is what happened very recently. On the 2nd of July 2026, the Ministry of Justice announced that Baird would remain interim chair for another 12 months from the 9th of December 2026, taking her to the end of 2027. The government specifically stated that this extension was intended to allow Baird to continue implementing the recommendations arising from her review and the HMC PSI inspection. So, in broad terms, I would characterise the tenure of Baird as her having inherited a CCRC suffering pretty much the worst leadership crisis since its creation, and arguably one of the worst leadership crises in the history of the British court system. She has been markedly more candid about its problems than the previous leadership, commissioned an external inspection, overseen leadership and commissioner changes, produced a reform programme, and has now been kept on specifically to implement those reforms. It must be said as well that Baird seems to be concerned about optics and has made herself a lot more visible than people that were previously in the role. Baird is also not merely an administrator. She is a former criminal barrister and QC, former Solicitor General, former Victims Commissioner, and former Police and Crime Commissioner. That gives her an unusually broad experience of prosecution, defence, policing, and the interests of victims. In the context of Lucy Letby, that matters a great deal. Her application is being considered by a CCRC that is under exceptional public scrutiny and being actively reformed precisely because of previous failures to identify miscarriages of justice. It would be very difficult for the present CCRC simply to dismiss substantial new expert evidence without demonstrating that it examined this evidence rigorously. Part 6. The Thirlwall Inquiry. As of the 7th of August 2026, the Thirlwall Inquiry has finished hearing evidence of submissions, but its final report has still not been published. Lady Justice Thirlwall formally brought the evidence of submissions phase to a close on the 19th of March 2025. Since then, the inquiry has been drafting the report, issuing warning letters to people who may face explicit or significant criticism, working through publication procedures, and continuing to upload evidence and documents to its website. The most recent official publication update is from the 12th of May 2026. The inquiry said the report would be published at the earliest practical date, but not until after the summer recess of Parliament. It has not yet announced a specific publication date, although even just days ago, new documents were published by the inquiry. It should also be mentioned that this 12th of May 2026 date is long after the report was supposed to have been released. Indeed, on the 27th of February 2026, the inquiry said drafting was very well advanced and that it expected soon to send a final draft to publishers for copy editing, typesetting and proofreading. Then on the 21st of April 2026, it said considerable progress had been made, but that it could still not yet announce a publication date. So the current position is essentially that the public hearings are finished, the closing submissions are finished, the report drafting is seemingly very advanced, warning letters have gone out, but the final report is yet to be published, and we don't know when that will happen, just merely that it won't happen before the summer recess of Parliament. There is another important point in the context of the Lucy Letby case. The inquiry's terms and structure take the criminal convictions as their starting point. Its stated purpose is to examine what happened at the Counters of Chester and the response of the NHS staff and regulators following Letby's convictions. It is not an appeal tribunal tasked with reconsidering whether the convictions are safe. That creates an increasingly unusual situation at this point in time. The Thirlwall report is still being prepared, while separately the CCRC is actively reviewing Letby's convictions on the basis of substantial new submissions and expert reports. The CCRC confirmed in February 2026 that its review was underway and that it had continued receiving additional expert reports and submissions through January 2026. So at present, the two processes are moving on very different tracks. Thirlwall is preparing findings premised on the existing convictions, while the CCRC is considering whether new evidence creates a real possibility that those convictions will not be upheld. That tension is probably the most significant aspect of the inquiry's present status. As we know, one of the paradoxes of the Thirlwall inquiry is that, although it was not established to reconsider Lucy Letby's convictions, the enormous volume of contemporaneous material it has published has proved extremely useful to people scrutinising those convictions. The inquiry explicitly starts from the fact of the convictions and examines the hospital's response, rather than asking whether Letby was guilty. Yet some of the documents, indeed many it has disclosed, cut against simplified versions of the prosecution narrative. One such example is Lucy Letby's 2016 grievance investigation. Dr. Christopher Green recorded that during his investigation, he had not been made aware of any evidence relating to any alleged wrongdoing by Lucy Letby. What he had repeatedly encountered was the commonality between her presence and the collapses or deaths. That becomes even more significant on another page. When Dr. Stephen Breary was asked what his concerns about Letby were, the grievance report records his answer as only the association with her being on shift and the death of the babies. Dr. Ravi Jairam was recorded as saying that they had concerns and had noted the association with Lucy being present. Green concluded that preliminary fact-finding by executives had produced nothing prompting a formal internal or police investigation at that stage. Then he openly criticised Breary and Jairam, and the latter is facing some extremely serious consequences based on recent leaked police documents. Now, we know beyond doubt at this point that there is an enormous amount of information that has come out from Thirlwall that can be used in the defence of Lucy Letby. And this can be placed into 5 broad categories: origins of suspicion, contemporaneous records indicating that the initial concern centred heavily on Letby's association with the deaths and collapses rather than solid evidence. The denominator problem. The inquiry has made much more visible the complete mortality picture rather than merely the incidents selected for prosecution. Hospital system explanations. Staffing, skill mix, infections, transfers, admission criteria, infrastructure and changes in clinical practice provide a much richer background against which deterioration has to be interpreted. Contemporaneous versus retrospective interpretation. Documents allow us to see what doctors, pathologists and managers actually believed in 2015 to 2017, as distinct from what experts concluded years later after homicide had become the hypothesis. And finally, reliability of the narrative. Internal disagreement, changing descriptions, and contemporaneous uncertainty complicate claims that there was one obvious, steadily accumulating body of evidence pointing inevitably towards murder. Thirlwall has inadvertently produced an enormous contemporaneous archive that allows the prosecution narrative to be audited in a way that was previously impossible. And of course, the jury and court did not hear this vast array of information. And some of the archive shows that the reality was considerably messier than what was described in court. There were more deaths than appeared on the famous chart. Babies died after transfer. The neonatal unit had significant operational infection control issues. The unit's clinical profile changed when Letby was removed. The original suspicions were heavily association-based. Contemporaneous internal investigation had not uncovered concrete evidence of wrongdoing at the point when Letby was removed, and of course there were other collapses and deaths that the court never heard about. When combined with the later medical reassessment, statistical criticism, heavily disputed science and investigative concerns, it can contribute significantly to an argument that the original cumulative case was less secure than as presented to the jury. In that sense, the Thirlwall inquiry may ultimately have done something it was never intended to do, create one of the richest sources of material available for testing the safety of the convictions. That is one of several reasons why Lady Thirlwall now finds herself in an invidious position, handcuffed by the terms of reference of the inquiry named after her. Part 7. Specifics of the Letby case. The raw fact that only 2% of applications are referred should not be interpreted as meaning that Lucy only has a 2% chance. Most CCRC applications do not resemble hers in any way. Around 40% in some years come from people who have not even exhausted their ordinary appeal rights, and many applications contain no genuinely new evidence capable of meeting the statutory test. The Letby application is highly unusual because it involves numerous new specialist reports, a multinational medical panel, new peer-reviewed neonatal insulin research, challenges spanning multiple medical mechanisms, potentially new statistical arguments, material that postdates the first Court of Appeal judgment, and an exceptionally high-profile whole-life murder conviction. The key questions would likely include whether genuinely new material now exists concerning the diagnosis of deliberate harm in individual babies, alternative natural or iatrogenic explanations, the scientific interpretation of the insulin and C-peptide results, new peer-reviewed neonatal insulin research, expert criticism of air embolism diagnoses, previously unused statistical analysis, door swipe and timeline evidence, disclosure issues, and whether the cumulative prosecution case remains as strong if some of its underlying medical propositions are materially weakened. The CCRC would then ask, could this material, taken seriously and placed before the Court of Appeal, realistically cause that court to conclude that one or more convictions are unsafe? And then on top of that, there are three enormous factors: unprecedented media pressure and support, enormous medical expertise on her side, and conversely, it's very difficult and possibly impossible for the prosecution to attract any witnesses at all. So I have my opinion on this, which I'll go over in a second. But I thought it would be an interesting exercise, and I don't usually do this, to ask ChatGPT to do some deep research and then come to a conclusion. So I said, based on everything you can ascertain, being as critical as possible, do you think these crimes are proven beyond reasonable doubt? No. Based on the evidence now publicly available, I would not regard the alleged murders and attempted murders as proved beyond reasonable doubt. The prosecution case now, I won't read all of this, the prosecution case now contains too many serious, interconnected uncertainties for me to be sure that deliberate attacks occurred, still less that Letby committed them. Why do I think the threshold is met? Why do I not think the threshold is met? It is no longer medically clear that the crimes occurred. And then they're talking about the learning language model here is talking about the number of specialists and how, at the end, I cannot see how deliberate harm remains the only reasonable inference without those competing views being properly examined before a jury. The case appears to have developed through a potentially circular process. Staff noticed a cluster of death and collapses. Letby appeared frequently associated with selected incidents. Suspicion focused on her. Medical records were then reviewed for possible mechanisms of deliberate harm. The incidents judged suspicious became the evidential pattern used against her. So there's some talk about that. The medical mechanisms were unusually heterogeneous and sometimes changed. So these obviously included air, milk, insulin, physical trauma, interference. A serial offender could use several methods, but when there is no eyewitness confession, forensic trace, or consistent pathological signature, the diversity of mechanisms weakens the claim that one clear pattern has been identified, a common criticism. The insulin cases are no longer a safe anchor. So I'm going to go on to discuss that later on because I wanted some further information. The hospital offered substantial alternative explanations. The Counter-Chester neonatal unit was not a controlled environment in which all ordinary explanations have been eliminated. The public material describes staffing shortages, breaches of expected nursing ratios, limited consultant presence, lack of dedicated neonatologists, higher acuity babies, transfer difficulties, infection and infrastructure problems, and concerns that the unit was treating babies beyond its appropriate capability. And they're talking about the downgrading of the unit and all of these things. The circumstantial evidence is weaker than its presentation sometimes suggests. There were no witness who saw Letby inject air or insulin, overfeed a baby, strike a baby, or deliberately dislodge a tube. The handwritten note was not a clean confession. It contained denial, self-accusation, despair, fear, and contradictory statements. And then they're talking about other anecdotal aspects that we know are very weak. Some apparently precise timeline evidence proved unreliable, so talking about child K and other problems with the timeline and swipe data here. The strongest argument for guilt is the cumulative coincidence of Letby being repeatedly present, some babies deteriorating, etc., etc. But cumulative reasoning is only as reliable as the relative independence of its components. Here, many components may derive from the same original hypothesis. The incidents were selected because Letby was associated with them. Medical findings were retrospectively interpreted within that selection. Her presence then reinforced the medical interpretation. The medical interpretation made her paperwork, searches, and behaviour appear more sinister, and the insulin cases were used to support inferences in medically different cases. That creates a risk of double counting dependent evidence. 10 mutually reinforcing interpretations are not equivalent to 10 independent facts. And of course, you've seen me show you this circular process that they went through. This is exactly the word used here. This circularity, essentially making exactly the same argument. On the public record, I would divide the questions as follows. Was the neonatal unit experiencing a concerning cluster? Yes. Were some events unusual? Yes. Are there circumstances involving Letby that remain suspicious? Yes. Can I exclude the possibility that she deliberately harmed one or more babies? No. Has the prosecution evidence established that deliberate attacks occurred? In my assessment, no. Has it established beyond reasonable doubt that Letby was responsible for those attacks? No. I would place the case well below the degree of certainty required to imprison someone for life without release. I would not presently be willing to convict. My critical assessment is there is now a substantial and rational reasonable doubt arising not from one technical objection, but from the combined effect of disputed proof that crimes occurred, credible natural and iatrogenic explanations, selection and confirmation bias risks, weaknesses in the statistical presentation, changing medical theories, contested insulin evidence, serious hospital deficiencies, evidential and disclosure problems, and the lack of direct or uniquely incriminating evidence. I therefore think the conviction should be referred back to the Court of Appeal and the new evidence tested adversarially. Whether the ultimate result should be acquittals or retrials may depend on what survives that testing, but on what can currently be ascertained, I do not believe the crimes are proved beyond reasonable doubt. So then I said, I want to give you a further opportunity. Can you see anything based on all the information available which points to the conviction of Lucy Letby being proven beyond reasonable doubt? If you assess everything from both sides, do you stand by your view that you would not convict and that there is definitely doubt in this case despite the court verdict? Do you also believe that the CCRC should refer to the Court of Appeal? Can you see any legitimate reason not to do this? And after some thought, the LLM said, yes, I stand by my assessment. On the publicly available evidence, I would not convict Lucy Letby. I think there is substantial, rational and case-specific reasonable doubt. On the evidential picture now available, I would not convict. I think there is clear reasonable doubt over whether deliberate harm occurred in several or all of the cases, whether the insulin episodes were scientifically established as poisoning, whether the proposed mechanisms were reliable, whether the apparent pattern was affected by retrospective selection, and whether the non-medical circumstantial evidence has substantial independent value. Accordingly, I believe the CCRC should refer the convictions to the Court of Appeal. Although legitimate legal arguments against referral exist, I cannot currently see a convincing evidential justification for denying a fresh appellate examination of material this extensive and this fundamental. So then I gave it a third opportunity, and what I'm trying to do here is prompt the model to change its mind, to change its thinking, and to tell me what I want to hear, to change its view. But it will not do that on things where there is strong evidence. So, you can't make it change its mind on a fact, for example. But I'm trying to prompt the model here to change tack. So I said we previously discussed whether or not Lucy Letby has been convicted beyond reasonable doubt. You looked at all available evidence and concluded twice that she is not. I'm going to give you a third opportunity now. Can you see a smoking gun in the Lucy Letby case? Is she convicted beyond reasonable doubt? Please take into account all available evidence, everything we know about the case, recent submissions, including Chase and Shannon, the prosecution case, etc. Yes, having reassessed it again, including the prosecution case, both Court of Appeal judgments, the International Medical Review, the insulin challenges, the new Chase Shannon peer-reviewed paper published on the 5th of August, the statistical criticisms and the present CCR position, my conclusion is still the same, and on the insulin cases it is now somewhat stronger than before. Is there a smoking gun? I cannot identify one. The original prosecution was explicitly a circumstantial case. The Court of Appeal describes the prosecution relying on medical experts together with Letby's presence, shift patterns, treatment records, alleged false documentation, handover sheets, Facebook searches and handwritten notes. It was never a case involving CCTV of an attack, a witnessed injection, a recovered poison bag, a forensic trace tying Letby to sabotage, or an unambiguous confession describing a crime. The insulin cases were the closest thing to a smoking gun. They no longer look like one. My assessment of the evidential position as it exists in August 2026 If I were a juror today and heard the complete prosecution case, the original prosecution medical experts, the 14-member international panel, the detailed alternative diagnoses, the insulin specialists, Chase and Shannon's neonatal data, the limitations of the insulin assays and absence of definitive forensic confirmation, the statistical concerns, the broader hospital context, the problems inherent in retrospective case selection, the evidence around Child K, and the circumstantial evidence concerning the notes, searches and documents, I could not conscientiously say that I was sure she committed these crimes. My overall conclusion: if anything, Chase and Shannon made my earlier conclusion more secure because the insulin cases were the one part of the prosecution case I previously thought might provide independent objective proof that at least somebody had deliberately harmed babies. I am now considerably less confident even in that proposition. The new paper does not prove natural causation in children FNL, but it shows that the central biochemical feature, previously treated as highly indicative of exogenous insulin, occurs surprisingly often in neonates with no insulin exposure at all, and specifically warns against applying adult older child expectations automatically to premature babies. Therefore, my answer after giving the prosecution case the strongest interpretation I think it reasonably bears is no, I cannot identify a smoking gun. No, on the current publicly available evidential record, I would not find Lucy Letby guilty beyond reasonable doubt. Yes, I think there is substantial, rational, reasonable doubt, not merely theoretical doubt, about both whether several of these events were crimes in the first place and whether Letby caused them. Now, there is a good reason for that. As I mentioned in a previous video, all these people in green are experts who come out in favour of this being a wrongful conviction or miscarriage of justice. And all these red people here were paid in the original trial. Professor Jane Hutton, who is neutral, is basically on the side of the miscarriage of justice and defence. And there's just no one has come forward at all who is an expert, and this is dozens and dozens and dozens from the Jolly Contrarian site. Then, in addition to that, that's not an exhaustive list. Here's a collage of people that I've interviewed, some of whom are outside of that list. And then, in addition to that, I've interviewed more experts for my book who I've not interviewed on YouTube. Then I'm in contact with dozens and dozens of other people, and there's going to be more experts coming soon. There's going to be more interviews soon with people you haven't heard from previously. Then on top of that, there's over 1,000 medical professionals and allied medical professionals in 19 nurses. And there isn't a single person opposing any of these people, and it's going to be almost impossible for the Court of Appeal to attract anyone, and no one is ever going to speak out. I'm going to discuss the reasons why no one is ever going to speak out in favour of the prosecution, that is, in a forthcoming video. So when you consider the exceptional weight of medical evidence, the calibre of medical experts acting in Letby's defence, the extremely detailed and specific reports, the open condemnation of expert evidence, particularly the evidence from Evans, the compromising of Evans, Bohin and Hindmarsh that has already occurred, the fresh evidence that is readily available, the enormous media spotlight and pressure, the fact that the CCRC is facing huge public scrutiny and criticism, and the fact that Vera Baird has been brought in amid pressure for reform, and perhaps also the fact that it seems the Thirlwall inquiry report has been permanently delayed. If you put all those things together, I really think it's just a matter of when, not if, this case is referred. I think the referral is as close to being inevitable as anything could be, because to ignore all of these things now, in considering the weight of evidence, considering the number of experts that have come forward, considering everything we know about the case, considering how flimsy the prosecution case is, considering all the revelations, the recent leaks, the fact that JRAM is now facing very serious accusations of perjury, all the Thirlwall documents that have come out, everything that we know now, look at the weight of public opinion. When I was interviewed by the Daily Telegraph, there were over 3,500 comments. They are almost uniformly supportive. All of the top-rated comments, you have to go into the dregs of the comment section before you find anyone that knows about the case or that is aware of the case who will say, oh, I think Lucy Letby is definitively guilty. And I must say, most of those comments are borderline illiterate, because every serious and credible person now believes this is a wrongful conviction, that it's a miscarriage of justice, and it's one that I believe will just inevitably be referred to the Court of Appeal. At that point, the Court of Appeal will know that the eyes of the country, and indeed the eyes of the world, are watching them.